Hi, this is Joe from PrepAgent, and today we are talking about federal acts related to fair housing. It might seem obvious to us now that no one should be discriminated against when they try to buy a house. But that was not always the case. It took many federal acts to finally provide legal protection against discrimination. To pass the real estate exam, you must know what these acts are and who they protect. As a real estate agent, you must understand the federal fair housing laws and apply them in real-life practice. Let's go over the most important fair housing acts. The Civil Rights Act of 1866 was enacted in April of 1866. It was the first United States federal law to define citizenship and affirm that all citizens are equally protected by the law. It came about in the wake of the Civil War, and its primary intention was to protect the civil rights of African descendants born in or brought to the United States. In regards to real estate, this law essentially prohibits discrimination based on race or color during the purchase, sale, lease, or conveyance of real property. The Civil Rights Act of 1866 basically says that, without exception, all citizens have the same rights regarding property regardless of race. While the Civil Rights Act of 1866 is important, there is a court case that happened in 1968 that's considered almost equally as important. The Supreme Court case Jones v. Alfred H. Mayer Company affirmed that the 1866 Act prohibited any discrimination on the basis of race by private individuals and the government with no exceptions. The Supreme Court decision was based on a section of the U.S. Code which basically prohibits racial discrimination in all sale and rental of property. The Supreme Court ruled that the enabling clause of the 13th Amendment gives Congress the power to enforce the statute of the U.S. Code. The major significance of the decision was that not only is the government prohibited from discrimination in housing, so are private individuals. The 13th Amendment to the United States Constitution abolished slavery and involuntary servitude, except as punishment for a crime. The Fair Housing Act of 1968 is more technically known as Title VIII of the Civil Rights Act of 1968. This act prohibited certain actions that were viewed as discriminatory with respect to housing, and it specifically defined the groups to which it applied. These were called protected classes. Unlike the 1866 Civil Rights Act, this one included specific exceptions. The 1968 Act is enforced by the Department of Housing and Urban Development, HUD. The Department of Housing and Urban Development has created a fair housing poster that must be prominently displayed in all real estate offices. Failure to display the sign can be considered non-compliance with fair housing law and will be used as evidence of discrimination wherever a complaint is brought against a brokerage. HUD also requires that its fair housing logo or appropriate wording that is similar is to be used in all advertising. The Americans with Disabilities Act, ADA, became law in 1990. The ADA is a civil rights law that prohibits discrimination against individuals with disabilities in all areas of public life. This includes jobs, schools, transportation, and all public and private places that are open to the general public. The purpose of the law is to make sure that people with disabilities have the same rights and opportunities as everyone else. Understanding these items is important for helping you pass the real estate exam, but they also give us a better understanding of just how much value the United States places on giving us the equal opportunities we all need to prosper and succeed. This is Joe from PrepAgent, reminding you to keep it concise and keep it simple.